Good morning. Welcome to the Supreme Court of the United Kingdom. Today, we are hearing an appeal from the Divisional Court of the Queen's Bench Division in the matter of Zabolotnyi and the Mateszalka District Court, Hungary. This is an extradition case. The particular issue relates to conditions in Hungarian prisons and the approach to be taken in assessing and relying on assurances as to prison conditions given by the Hungarian authorities. I'm Lord Lloyd Jones, and today I'm sitting with Lord Hamblin, Lord Leggett,
Good morning.
and Lord Stevens.
Good morning.
The appellant, Mr. Zabolotnyi, is represented by Jonathan Hall, Queen's Counsel, Benjamin Seaford, and Florence Iverson. Respondent, the Mateszalka District Court, is represented by James Hines, Queen's Counsel, and Amanda Bostock. Mr. Hall.
Good morning, my lords. Just as I start, can I say several of your lordships are occasionally blanking out, but you're all visible now, so if I miss a hand, please forgive me. My lords, by way of introduction, the accession to the European Union of former Eastern Bloc countries has posed a historic challenge for the operation of the EU arrest warrant scheme. The general prison conditions in those countries are frequently poor and often inhumane. And in a case called Varga, which concerned conditions in Hungarian prisons not so long ago, between 2011 and 2014, the Strasbourg court found that prison conditions in Hungary were generally inhumane. I won't take my lords to it, but it's at EF 1061. What this means in practice is that many former Eastern Bloc countries who wish to extradite must rely on assurances that whatever the general conditions, the requested person will be treated in a way that is consistent with fundamental human rights. And as in the present case, assurances in this area frequently concern the amount of minimum space that a prisoner will be guaranteed if they are returned. The assurance in the present case, again, I won't take you to it, but it's at EF 160. It may be asked, what is the importance of space? And the answer is that it is a convenient proxy for measuring the humanity of prison conditions or otherwise. Small amounts of personal space mean worse hygiene, less ventilation, more violence from other prisoners, and cumulatively a destruction of self-worth. So the question of overcrowding and the amount of personal space is generally a very fundamental question when considering prison conditions. And the leading case in Strasbourg is the case of Mersic. That is, again, I won't take you to it, it's at EF 880. And the general rule propounded by the Strasbourg court, adopted by the domestic courts here, is that where an individual has less than 3 square meters of space, there is a strong presumption that there is a violation or will be a violation of Article 3 of the Convention. As my lords know, this case concerns the testing of those assurances. It cannot be emphasized too much from the appellant's point of view that assurances are only in play because it has already been established that the appellant would risk of inhuman or degrading treatment if returned to Hungary. In these circumstances, as is reflected by the authorities to which I will turn in my submissions, we say that an inquiring mind is needed in assessing those assurances. And that, in summary, is the extent of the modest submissions that the appellant makes. The appellant's case is simple, that evidence that another country has breached assurances in the past is relevant, and no special bar to admission of evidence arises just because the evidence concerns assurances given to third countries, here Germany. And my lords, you will have seen the certified question, reference EF 67, and that expressly asks whether there should be a difference in treatment between assurances given in the past to the United Kingdom, which may have been breached, and assurances given to other countries. So that's the first part of the certified question. And the next part of the certified question goes on to ask whether there is a special test of admissibility. And essentially, the divisional court's judgment breaks into two to some extent and pulls in opposite directions. The divisional court, and if I can just take my lords to EF 81, paragraph 37. The divisional court accepted at paragraph 37, second sentence, that if a serious issue has been raised as to whether another state will in fact treat a person extradited from the UK in accordance with Article 3, this court is not precluded by any rule of law from having regard to any material evidence bearing on that issue. And we respectfully agree with that. However, what the divisional court did go on to do is to propound the test for admissibility, which my lords see on EF 83 at paragraph 44. I won't read it out, my lords will have seen that. And the case against the appellant in this court is that the divisional court has not done anything special, but merely applied the existing rules as to the admissibility of evidence. And that is clear from the respondent's notice of objection to this case, EF 25, paragraph 5. We say that that is not correct, that the divisional court was not simply applying existing rules of evidence, and that is clear on a straightforward reading of domestic, Strasbourg, and Luxembourg authorities. And we say that for these reasons, the appeal should be allowed and the matter remitted to the divisional court, effectively to consider the evidence without any sort of artificial straitjacket. And just so my lords have in mind the evidence upon which the appellant wished to rely, can I refer my lords first of all to EF 141. EF 141 is in the middle of an expert report from a Dr. Kadar, and he sets out quite a lot of detail about an individual called Mr. Kulshar. I should begin, sorry, at EF 139, paragraph 24. And this is one of the individuals to whom a guarantee was given to the German authorities. You see from paragraph 24 that he would be assured 3 square meters of personal space. And then I won't take my lords through it all, but in summary, at paragraph 38 on EF 141, Dr. Kadar says that there seems to be ground to assume that during the first 9 months of the detention, that assurance was constantly breached, since he was not provided with at least 3 square meters of space. Then the other German assurance relates to a man called Schicksai, and if my lords can go forward to page EF 148, Mr. Schicksai's assurance was slightly different. You can see at paragraph 87, Mr. Schicksai was guaranteed, again the guarantee being given to the German authorities, that if extradited to Hungary, he would be placed in a single occupancy cell. This did not happen, and at paragraph 88, the last 3 sentences records that on one occasion, he was placed together with 3 other inmates. The cell was not very spacious. He cannot remember the measurements. The cell was infested with bedbugs, suffered a lot of bedbug bites. He was there during the summer, extremely hot, and he was allowed to shower only 3 times a week. And the appellant before the divisional court wished to make the obvious point that if the Hungarian authorities were willing to break assurances given to Germany, then they might be willing to break assurances given to the United Kingdom. Can I just take my lords to how the divisional court dealt with the evidence? It is at EF 87, what my lords will see under the heading "The Two German Cases," the court summarised effectively the allegations by the appellant at 65 and 66, and at 67 observed or re-observed that the Ministry of Justice of Hungary had provided no information to contradict the evidence in these two cases because of Hungarian data protection. Hence, we are without the other side to these stories. And then at paragraph 69, their final conclusion on this: not appropriate in this case to make findings of fact in relation to the German cases, given the paucity of evidence available to us. Effectively, the Hungarians neither confirmed nor denied what the position was in relation to those two prisoners, and they declined to ask questions of Hungary. My lords, that's a reference to the mechanism under the framework decision, Article 15.2, that enables one authority to ask questions of another. It's something that happens very commonly in practice. I won't take my lords to it, but Article 15.2 of the framework decision is at EF 578. And just to complete the picture, as my lords will have picked up from the judgment, it was tolerably clear to the divisional court that if they had asked a question under Article 15.2, then the Hungarian data protection laws would not have prevented the Hungarian authorities providing the answer. So, my lords, that's what I propose to say by way of general introduction. As to the structure of the remaining submissions that I have, I adopt our case. I don't intend to reiterate it. I intend to try and illustrate the basic point that where Article 3 rights are in play, as a matter of Strasbourg jurisprudence, there is no artificial limitation concerning the court's inquiry into assurances that are given. And then I will turn to the CJEU authorities and address the question of whether or not CJEU authority means one should have a different approach. And then finally, I will turn to the decision of Feni Vassi, which concerns the admissibility of evidence on appeal, on which the respondent places significant weight in their case. So, my lords, when looking at the assessment of Article 3 compatibility of prison conditions, the Strasbourg court has historically invited what it calls a free evaluation in particularly difficult circumstances, because they won't be able to have access easily to all the information that they might need. The authority on that case is Ananyev. It's at EF 848, and I won't take my lords to it, but paragraph 121 in particular. And domestically, it's been recognised that there are no bright line rules about the assessment of evidence. In the case of GS, which is at my lords EF 1591 at paragraph 22, Lord Burnett observed that the Strasbourg court had been careful to avoid any identification of bright lines with respect both to whether prison conditions might violate Article 3 standards, and also as to whether an assurance is adequate to mitigate any established risk. So on the approach, the Strasbourg court's approach to the assessment of assurances leading cases, of course, Othman, can I just take my lords briefly to that, although I know that you will have no doubt had that well in mind. EF 1032, and my lords will have read it, but the relevant paragraphs in particular 187, 188, and 189. What the court is concerned about is that assurances aren't an automatic get out of jail free card for the requesting state, that one has to examine them, that one has to look at how those assurances have operated in practice, including in similar cases. And if I can just take my lords to paragraph 7 within paragraph 189. So the court needs to have regard to the length and strength of bilateral relations between the sending and receiving states, including the receiving state's record in abiding by similar assurances. Now, it's apparent that the Strasbourg court is not simply saying you can only have regard to the record of complying with here assurances given to the UK, but to similar assurances, which would include assurances given to Germany. And that point is made good because the Strasbourg court at footnote 87, don't know my lords can see just at the end of subparagraph 7, if you look at the footnote at the bottom of the page, you can see that they cross-refer to the case of Ahmad, and we have Ahmad in the bundle. And if I can just briefly take my lords to EF 781. Ahmad was a case involving assurances given by the Americans. It was a prison condition case, a different sort of prison condition case. But at 106 and 107, the Strasbourg court makes the point, picked up in Othman, that one has to evaluate assurances. And in particular, at 107, if I can just read the first sentence, in further assessing the practical application of the assurances which have been given by the United States government, the court must also attach some importance to the fact that the applicants have been unable to point to a breach of an assurance by the United States government that has been given to the United Kingdom government, or indeed any other contracting state. So, my lords, as a matter of Strasbourg law, one cannot draw artificial distinctions between assurances given to different states. The respondents in their case, the closest that they come to justifying a distinction, if I can take my lords to their printed case at EF 59, paragraph 25, by way of justification, says that it acknowledges the weight to be given to any assurance affected by the length and strength of bilateral relations between the sending and receiving states. In the context of evidence of foreign breaches, therefore, it is apparent that a UK court is not best placed, or indeed at all placed, to apply this factor. And with respect, we disagree with that. There's no reason why a UK court should not have regard to a breach of an assurance given to, at that stage, a fellow member state of the European Union, namely Germany. My lords, I don't intend to address the case of Fusesi anymore, but it's referred to in the previous paragraph. In that case, Lord Justice Singh referred to, and you can see from the paragraph above, that in that case it was crucial in our view that there is no evidence any assurance to the UK in respect of an individual had been breached. The relevant passage, I won't take you to it, is at EF 1544, but we submit that Lord Justice Singh, the Divisional Court, were not purporting to lay down any general rule, and that was simply concerned with the facts of that particular case. As you'll see when you look at the case, these were anonymous assurances, very different from the situation in the present case. So can I turn then to the question of whether or not, notwithstanding the Strasbourg authorities, a different approach is called for when assessing assurances because of the Luxembourg jurisprudence. And we submit that there's nothing in the Luxembourg case law which does create a bright line of evidence. And I've got, under this grouping of submissions, I've got some 7 points to make. And first of all, my lords will recall that the framework decision is based upon what you might call a no-checking principle. In other words, save in exceptional circumstances, it's not open for an executing judicial authority to check on whether general prison conditions comply with Article 3, or indeed when any other conditions comply with any other provisions of the Convention. And if I can take my lords to Dorobantu, the decision of the Grand Chamber that's been referred to by both parties at EF 670. At paragraph 47, the court says that when implementing EU law, member states may, under EU law, be required to presume that fundamental rights have been observed by other member states. So not only may they demand a higher level of national protection of fundamental rights from other member states than that provided by EU law, but also, and this is the passage I draw attention to, save in exceptional circumstances, and we'll come back to those words, exceptional circumstances, later in my submissions, they may not check whether that other member state is actually, in a specific case, observed the fundamental rights guaranteed by the European Union. However, the court has not excluded that there may be circumstances where that checking is required. And as my lords will have picked up, the foundational case there is the case of Aranyosi. And according to Aranyosi, if one achieves a certain level of internationally recognized evidence that there are problems in the receiving state, then one may conduct the checking exercise. And if one scrolls through in Dorobantu to paragraphs 51, 52, if I can just invite my lords to read those. And so this is the stage which is familiar in many extradition cases of asking whether, as a matter of generality, to use the prison context, prison conditions are generally poor. It's the stage that was achieved in Varga. It's the stage that leads the issuing authority needing to rely upon assurances. But if I can just, referring to the first sentence of paragraph 52, what my lords will see is in order to achieve that first stage, one has to adduce a particular quality of evidence. And I'll refer to that quality of evidence, if I may, as internationally authoritative evidence. So that is the internationally authoritative evidence that you need to demonstrate that generally the prison conditions are poor. In those circumstances, one may check whether or not an individual who's going to be returned is going to be treated in a humane manner. By contrast, this sort of evidence, what I call internationally authoritative evidence, is not referred to by the Luxembourg court in the context of assessing assurances that may be given. And we'll see that in a moment. But as a matter of common sense, it wouldn't work. There is no, and is not likely to be, any high-level case law or reporting from international bodies about whether individual assurances have been breached in specific cases. So the way in which the assessing of assurances to be done is first considered in a case called ML, which my lords will find at EF 720. And if I can invite my lords to read from paragraph 110 through to 114. So my lords, I'll come on in a moment to the distinction between assurances that have been given or endorsed or not given or endorsed, which is obviously an important distinction. But the point I'm making for present purposes is a negative one. The Luxembourg court does not say that when assessing whether assurances will be complied with, one needs to have what I've described as internationally authoritative evidence. My lords, neither have the domestic courts, so courts in this jurisdiction, interpreted the obligation to assess assurances as requiring some sort of internationally authoritative evidence. And in our printed case, I won't take my lords to it, but at paragraphs 22 to 24, which are at EF 46 to 47, we set out how the domestic courts have said that evidence of a single breach of an assurance would be relevant to assessing whether or not assurances will be complied with in the future. And domestic courts have not suggested that one needs internationally authoritative evidence or evidence of systematic breaches that have been identified by an international body or something of that nature. There is reference in some of the domestic authorities to what is described as the need for cogent evidence. And can I just deal with this point because it is relied on against me by the respondent. The leading case is the case of Ilia, and I hope my lords have got the supplementary authorities bundle, and I wonder if I can take my lords in that to EF 75. This is a decision of the divisional court. As you can see from paragraph 40, it was a case in which, in an EU framework decision context, the divisional court was assessing assurances. And in the judgment of Lord Justice Akins, he noted that it's important to recall that we are dealing with cases in which the assurance will have been given by the judicial authority or the responsible minister or responsible senior official of a government department of a Council of Europe or EU state. And then said this, in our view, there must be a...
Is this Mr. Hall? Sorry.
40.
Thank you.
Thank you. And the second sentence, in our view, there must be a presumption that an assurance given by a responsible minister or responsible senior official of a Council of Europe or EU state will be complied with unless there is cogent evidence to the contrary. Now, we don't disagree that where an assurance is given by a fellow EU country or by the United States, that there will be some sort of presumption that they will comply with it. But the reference to cogent evidence here simply reflects the nature of the presumption. It does not say, for example, that one needs to have the internationally authoritative evidence that one needs to breach the first stage in Aranyosi. Indeed, evidence that a state has given assurances to the past and has breached them would be cogent evidence. And if I can give my lords just references to two passages in two cases, I won't take my lords to them. Georgiev, back in the main bundle, EF 1568, paragraph 61. And Jane, EF 1617, at paragraph 55. And for completeness, this is the sixth point under this heading. It could not be said that internationally authoritative evidence is needed because responding to individual allegations that there have been past breaches would slow down the extradition process unduly as a matter of practicality. We don't agree. My lords, it is now highly usual in these sorts of cases for there to be a back and forth between the courts of the United Kingdom and the authorities or the issuing judicial authorities. Quite often one will have up to 4 or 5 pieces of further information, clarifying assurances, clarifying prison conditions, and the like. There is no reason why the respondent in this case could not have responded to a request made under Article 15.2 in relatively short order. So we don't agree that this would be some practical recipe for delay. And we referred in our printed case, I won't take my lords to it, to the duty of candour, which the issuing state has in any event. If the issuing state was aware that its authorities were breaching assurances, it would be obliged to disclose that in any event. The final point under this heading is that whatever evidential approach is taken should not lead to a situation in which the appellant's evidence is simply ignored because the respondent refuses to confirm or deny it. And my lords have seen what the divisional court said. Effectively, we haven't got the other side of the story. There's a paucity of evidence. Therefore, neither are we going to make a finding on it, nor indeed are we going to make a request under Article 15.2. And I mean, that would lead to a sort of catch-22 situation. If the evidence is clear and cogent, you don't need Article 15.2, but you can't use Article 15.2 unless your evidence is clear and cogent. So that concludes the submissions under the first topic about whether there's some special type of evidence that is needed in order to test or rebut assurances. And the next group of submissions concerns the strength of the presumption that a member state will comply with its assurance, having regard in particular to Dorobantu. My lords, to some extent, this is a second order consideration. If the appellant is right in the first submission that I've made, that all types of evidence are admissible, even if there is a strong presumption that Hungary will comply, that's not inconsistent with allowing all forms of evidence in order to test whether that assumption has been rebutted. But I do submit that one needs to be careful not to overstate the effect of the presumption of compliance. And in particular, ML, and we've looked at it, I won't take my lords back to it, does not say that one can only rebut an assurance if one shows exceptional circumstances. And the closest that one comes in ML is that distinction between, on the one hand, an assurance that's either given or endorsed by the issuing judicial authority, in which case it must be accepted absent specific indications to the contrary, and on the other hand, where it is not given or endorsed by the issuing judicial authority, in which case it must just be assessed in a general open-handed way. That distinction, we submit, is readily explicable as a point of principle. And in the supplementary authorities bundle...
Forgive me, Mr. Hall. The first of those categories where the assurance is given or endorsed by the requesting authority. In what circumstances do you say can be questioned?
It's easy if I just take my lord to the page. The main bundle, if I may, EF 720.
In ML paragraph
112. And it's the reference to, and the third line up from the bottom of that paragraph, at least in the absence of any specific indications. And by contrast, 114, where an assurance is not given by a judicial authority, it must be evaluated by carrying out an overall assessment of all the information available to the executing judicial authority. And as my lords know, we say we are very much in the latter category. I'll come on to the details of the assurance in a moment, but it was given, the reference is EF 158, it was given by the Ministry of Justice, not by the issuing authority. It was given to the National Crime Agency. I'm sorry, my Lord Legate.
Yes, I just wanted to ask, what is the test of confidence or satisfaction in an assurance that needs to be met in order to accept it? What is the standard applied? Is there a legal authority for that?
I think there is, and I'll come back to my lords if I may on it, but I think the general point is that it's got to be sufficient to ensure that the individual will not be exposed to inhuman treatment. But in terms of the, yes, may I come back to my lord on that?
Yes, sure.
All right. I've got my juniors in the room. I'm just going to turn to them if I may. Perhaps would you? Thank you.
So the assurance given in the present case was given by the Ministry of Justice in Hungary, not by the requesting authority.
That's right. Now, one may ask, what is the rationale for distinguishing between, on the one hand, an assurance given by the issuing authority, and on the other hand, an assurance given not by the authority? And we submit that this is a distinction of principle on the basis that the foundations of mutual legal assistance are fundamentally the trust that one has for independent judges in other countries. That's why the extradition system works as it does, because one trusts that the judicial authorities in other countries who are making the request are doing so independently and fairly and accurately. In the supplementary authorities bundle at page 75, I don't think I need to take my lords to it, but we referred to the decision of the divisional court in Assange, and at paragraphs 49 to 50, Lord Thomas draws that sort of distinction. It's not exactly the same, but he's drawing that distinction of principle between the trust that one has in judicial authorities and the trust that one might have, the different sort of trust that one has in non-judicial authorities. And my lords will also perhaps recall from Othman, if I can just take my lords back to it, is EF 1033. Although this is obviously the Strasbourg court, interestingly, the 11th consideration that the Strasbourg court identified was whether the reliability of the assurances has been examined by the domestic courts of the sending or contracting state. In other words, whether there's some sort of additional guarantee that it's an effective assurance guaranteed by a judge. So, my lords, on the facts of this case, not given or endorsed by the judicial authority. That's not surprising in the context of a prison case. And I will say candidly that I can't really imagine a situation in which an assurance given by the Ministry of Justice concerned with prison conditions is ever going to be given or endorsed by an issuing judicial authority. But be that as it's may, that is the way that the Luxembourg court approaches the matter. And it follows that it had to be tested. There is no reference in ML, as my lords have seen, to saying that it can only be tested in exceptional circumstances. Now, can I, with ML in mind, now turn to Dorobantu, because the respondent does seek to make something of what is said in Dorobantu on this topic. If I can take my lords to EF 674. Paragraph 68 and 69, if I can invite my lords to read those paragraphs, please. So one sees from paragraph 68 that the court picks up that distinction between given or endorsed and not given or endorsed, although it only refers, in fact, to the first part of that. And it reiterates, based on ML, which we've seen, that the executing authority must rely upon that assurance if it has been given or endorsed, at least in the absence of any specific indications. So the first point to make is that the court in Dorobantu is in no way qualifying that distinction that was made in ML, although as it happens, it only refers, my Lord Legate.
Sorry, I didn't want to interrupt you, Mr. Hall. I just wanted to say that paragraph 69 probably answers my question, that if notwithstanding the assurance, there's considered to be a real risk of inhuman or degrading treatment, then the assurance won't suffice.
Thank you very much. Gratefully said that. And then paragraph I'm sorry, my lords, I've got you back now. Sorry. So the reference there is only there for an exceptional circumstances and on the basis of precise information, etc. Now, what the respondent does is to say, well, look at those words only in exceptional circumstances. It therefore follows that it is only in exceptional circumstances that an assurance is not going to do the job. We say that that reference to exceptional circumstances does not sit with the assessment of assurances. We've already looked at ML. There was no reference to exceptional circumstances in ML in the context of assessing assurances. Where it comes from, we submit quite clearly, is because the court in Dorobantu is looking at the entire process. And if you look at paragraph 61 on EF 673, the court is reiterating the principles that we've looked at. So at 61, in that context, the review of detention conditions in the issuing member state, which in the exceptional circumstances referred to in paragraphs 50 to 52 of the present judgment, is to be carried out. In other words, the checking process. And going back to 50 to 52, invite my lords to read that. So here we get back to that internationally authoritative evidence that we discussed. Yes, there may be exceptional circumstances where you have to do the checking if you have the internationally authoritative evidence. And so in its summary at paragraph 69, that is absolutely right. But the court in Dorobantu was not saying that one can only check assurances in exceptional circumstances. And we submit that would be a departure too far, frankly, from Hoffman, to which the court, the Luxembourg court, has had regard on numerous occasions. It would make an assurance effectively an automatic get out of jail free card for states whose prisons are in a terrible condition. So we submit that that is not the correct reading of paragraph 69. Finally, on this point, my lords, and I should say I'm making good timing, I think, with my oral submissions. The divisional court misunderstood our submission. It's obviously my fault that they did on this topic. If I can take my lords to EF 88. At paragraph 75, the divisional court said that we've considered the argument based on judgment of ML that courts in the United Kingdom should only accept assurances from requesting judicial authorities from judges rather than relevant representatives of the state. We reject that as a point of principle. I mean, that was not the argument that we made, but obviously I made it unclearly. We don't say that you cannot accept assurances from non-judicial authorities. It's just when they are not given by judicial authorities, you have to carry out a free evaluation of whether or not they are going to be complied with, and that involves looking at all relevant evidence. My lords, the third and final group of submissions concerns Fenevesi. And as my lords would have seen from the respondent's printed case, it is argued that because the appellant was seeking to rely upon Dr. Kadar's evidence for the first time on appeal, that evidence could only be admitted if it met a particularly high threshold of admission. And my lords, the case of Fenevesi, which I hope you've had a look at, is based upon section 27 to 29 of the Extradition Act. These are the provisions that enable the court to allow an appeal based on fresh evidence. And in Fenevesi, the divisional court interpreted these provisions as saying that effectively only where the evidence is particularly strong may it be admitted for the first time on appeal as a ground for allowing an appeal. And as I've said, the respondent places significant weight on Fenevesi in their printed case and says, well, look, the divisional court in the present case was bound to exclude this evidence because it was fresh evidence and it didn't meet the standards laid down in Fenevesi. And my lords, we have 4 submissions to make under this heading. The first is a short submission. The divisional court did not in fact rely upon Fenevesi. The second submission is that Fenevesi concerns a very different set of circumstances from those that occurred here. My lords, I'll give you the reference, but won't take my lords to it. It's EF 1757 to 9. And for the facts, it's worth looking at paragraphs 14 to 20. But what happened in Fenevesi, it was a classic fresh evidence case. The the authorities in that case had lost and had failed to address the evidence that was relied upon by the requested person. And then they sought to appeal on the basis that they now had evidence that would rebut those points. And the divisional court said, you can't do that unless it's really, really super strong. This case is, of course, very different. And it is necessary to look at a little bit of the procedural history. My lords, if one goes to the judgment of the district judge at EF 105, one can see at paragraph 17 of the judgment of the district judge that 5 lines up from the bottom. However, in these proceedings, there is no assurance for this requested person. That is because the Hungarian Ministry of Justice state that such assurances are no longer necessary following steps they have taken to comply with the decision in Varga. So that was the position at first instance. What then happened next chronologically is that the Hungarian authorities accepted that assurances were still necessary because their prison conditions were still so bad. And that was accepted in the case of Fuzesi. I'll give my lords the reference, EF 1539, paragraph 27. And that acceptance in the case of Fuzesi was in May of 2018, after the judgment of the district judge. And of course, then that affected all Hungarian cases going forward. And in fact, the issue of assurances only arose in this appeal after permission to appeal had been granted. So, my lords, as a matter of technicalities, this is a case in which the issue of assurances only arose for the first time on appeal. That is how the divisional court analysed the matter in a case called Gies. I won't take my lords to it, but it's in the supplementary authorities at page 6, paragraph 15. Whereas by contrast, Fenovesi concerned a case where new evidence arose for the first time on appeal. And then finally, in relation to Fenovesi, even in Fenovesi itself, the divisional court accepted that its strict reading would have to give way in cases of fundamental rights. And the reference is EF 1762, paragraph 34. My lords, we've included in, just looking for the Supreme Court authority on this, we haven't found anything directly on point, but we have included the case of Capri, which is a Scottish appeal to this court, the EF 1624. And one of the issues in that case was whether or not evidence about corruption ought to have been excluded when it arose the first time on appeal. There was a devolution issue which is not material, and the Supreme Court held that it shouldn't have been excluded. And paragraphs 33 to 34 of that judgment said it was sufficiently serious that it needed to be considered. There's no reference to section 27 or 29, no reference to Fenovesi, we would suggest, because clearly human rights were in play and the evidence had to be considered. And furthermore, not simply did Fenovesi recognise that there had to be an exception for human rights cases, but in subsequent cases, most notably the case of FK, the court accepted that the test for admission had to be based upon the interests of justice and drew attention to a case, and the reference is EF 1504, and we would suggest the relevant paragraphs are paragraphs 38, 40 and 43, 38, 40 and 43 drew attention to cases in which a respondent state is allowed to adduce evidence for the first time on appeal, rather like here, an assurance is given for the first time on appeal. And in the interest of justice, of course, an appellant faced for the first time with evidence needs to have an opportunity to call evidence if they can in rebuttal. So Fenovese does not represent anything like a bar to admission, and wasn't even referred to by the divisional court. My Lord Hamlin.
Can I just go back to your first point? You say divisional court didn't rely on Fenovese. In paragraph 78, they say that the evidence, still less that it would be decisive. Now, isn't that a reference to the Fenovese test? And secondly, presumably Fenovese was argued before the divisional court, or referred to.
Yes, my Lord, I make that decisive. I concede. I think I should have picked that up. I agree. That must be reference to it, and it certainly was argued. Yeah, my Lord.
Yes, I'd just like to know what your submission is on section 27 of the Act, and whether you're saying that this is a case that doesn't come within the provision that refers to a new issue being raised. Is that your submission? Or I think we ought to look at it, and I'd like to know exactly what you're saying about how it operates in this case.
Yes, it is at EF 1819. So I've got two submissions on this. The first submission is that we are within 27(4)(a), the first part thereof. An issue is raised that was not raised at the extradition hearing, because in effect, the respondent state conceded that the general Hungarian prison conditions were inhumane, thereby requiring an assurance to be given. And when one looks at that issue, we say, in the light of the German evidence and all the breach evidence, that issue ought to have led the district judge to have decided the question differently. The alternative, or the supplementary submission.
But that means it has to be decisive, the evidence.
The issue is decisive because the Hungarian authorities conceded that their prison conditions were generally inhumane. Once one concedes that, or if it is the case that the prison conditions are inhumane, and one cannot guarantee that the appellant would not suffer the same fate, that is decisive because it's a fundamental right.
So, sorry, are you saying that it's enough that the issue is potentially decisive if you decide it in one way, or does it have to, or to satisfy the test, you have to show that your case is correct on the issue, and therefore it's decisive?
Correct on the issue.
Yeah.
Correct on the issue. And the alternative is to say that the appellant was relying on evidence that is available that was not available at the extradition hearing, but that Section 27 does not in fact contain a test for admissibility. That is an inference that was drawn by the court in Fenovese, and that to the extent that decisiveness limits the admission of evidence, that word ought to be read in a way that is consistent with human rights obligations. And if the Strasbourg court says that when assessing an assurance to prevent inhumane treatment, that you must look at everything, then decisive must be interpreted with a degree of latitude and might even mean relevant. My lords, those are in fact my oral submissions. I've now concluded.
Good. Thank you very much, Mr. Hall. Mr. Hines, would you like us to take a short break now and take your submissions in one go? Or?
Yes, that would be very helpful, my lord.
Right. We'll take 5 minutes now, then. Thank you very much.
Thank you.
Mr. Hines.
My lord. My lord, the respondent's case is as set out in the 12 reasons that we have at the end of our written case, and that's at EF 60. But may I additionally start with some observations about the core materials, and particularly to assist your lordships, if we can go please to the framework decision, just to have some insight into the architecture or structure of it. It's in your core bundles at EF. It starts at 573, where the preamble is set out. And I'm going to start at 574, still within the preamble before we get to chapter 1 and the general principles. If your lordships look to the top right column at preamble 13, no person shall be removed, expelled, or extradited to a state where there's a serious risk that he or she would be subjected to the death penalty, torture, or other inhumane or degrading treatment or punishment. So that ultimately is the test in the preamble. On the same page, if we can go to the general principles, starting with Article 1.3 in the same column, that the framework decision shall not have the effect of modifying the obligations to respect fundamental rights and fundamental legal principles as enshrined in Article 6 of the Treaty on European Union, with the important paragraph above it, paragraph 2, that member states shall execute any European arrest warrant on the basis of the principle of mutual respect and in accordance with the provisions of this framework decision. Now, the only other preamble I draw the court's attention to is on the left-hand column at 10, that the mechanisms of the European arrest warrant is based on a high level of confidence between member states. Its implementation may be suspended only in the event of a serious and persistent breach by one of the member states of the principles set out in Article 6.1 of the treaty. And so it's against that background, if we can just briefly run through the structure of it. Over the page on 575, we needn't look at these in any detail, but the reference is made to them later in the framework decision. Article 3 sets out some grounds for mandatory non-execution. They include amnesty, final judgment elsewhere, and then on to 576 about age and criminal responsibility. They're not applicable in this case, but reference is made, as I say, later. And then in Article 4, some grounds for optional non-execution, that it's not under not an offence under the law of the executing state, that he is being prosecuted at 2, that there's been a decision not to prosecute. 4 is statute barred limitation, etc. So there's a few more there, but no reference is made to, for instance, prison conditions. That's in the preamble, as I've already taken your lordships to. Now, the framework itself says absolutely nothing about assurances. However, if I can take your lordships on to Article 15, which has been referred to by my learned friend, that is at 578. On the right-hand column at the bottom, Article 15, surrender decision. The executing judicial authority shall decide within the time limits and under the conditions defined in this framework decision whether the person is to be surrendered. And here is the power given to the executing judicial authority to request further information. If the executing judicial authority finds the information communicated by the issuing member state to be insufficient to allow it to decide on surrender, it shall request that the necessary supplementary information, in particular with respect to Articles 3 to 5, those are the mandatory and discretionary grounds for refusal, and Article 8, which is a consent, that information be furnished as a matter of urgency. And urgency is something that we have to come back to. Section 15.2 allows the executing judicial authority to fix a time limit for the receipt of the evidence. And I ask you to flick over to the next page, which is 579. At the end of Article 15 is 15.3, that the issuing judicial authority may at any time forward any additional useful information to the executing judicial authority. But the time limits are very significant when one is considering exercising this power to request further information. And those are contained in Article 17 on the same page, 579, in the left-hand column towards the bottom. A European arrest warrant shall be dealt with and executed as a matter of urgency. And throughout the authorities, the urgency for execution is emphasized. Then 2 is consent, does not apply. 17.3, in other cases, the final decision on the execution of the European arrest warrant shall take place within a period of 60 days after the arrest of the requested person, where in specific cases the European arrest warrant cannot be executed within the time limit laid down in paragraph 2 or 3, the executing judicial authority shall immediately inform the issuing judicial authority thereof, giving the reason for the delay. And in such cases, the time limit may be extended by a further 30 days. And so the framework decision that we have signed up to has very strict time limits. And that, we say, is important. Now, 15.2, the power to request further information is widely drafted, and it includes the giving of an assurance that there's good authority that in respect of a request for further information, the issuing judicial authority can give an assurance such as the one given in this case. And indeed, the judgment of the divisional court accepted that proposition that section 15.2 could be construed wide enough to inquire of Hungary about its breach of assurance given to the German executing judicial authority. So there was nothing in 15.2 to stop the court making the request for information that it could have done. However, One thing about 15.2 is that it is an inquiry for further information from the issuing judicial authority. It does not contain or contemplate that a request for information be made, for instance, of Germany or any other member state.
Is it
Now,
a request of the judicial authority, Mr. Hines, or is it of any authority within the state?
well, it's the issuing member state, in fact, the words, when one goes back to the wording, if the executing judicial authority, that's the court here, finds the information communicated by the issuing member state to be insufficient to allow it to decide on surrender, it shall request that the necessary supplementary information be furnished. So it seems to be rather broader than that, and it does have a wide remit, it would appear.
But the request is directed initially to the issuing
Judicial authority. Yes, but it's the information which has been communicated by the issuing member state that's referred to in 15.2. Well, this actually brings me to the point about time limits, that this case, and there are many like it, goes well beyond the time limits contained in Article 17 of the Framework Decision. As one could see, there are calls for the court, the magistrates' court, and indeed the divisional court on appeal to hold evidential hearings where the assessment is based on evidence presented to it, and that causes delay. Now, the Crown Prosecution Service, who instruct me, are the representatives of the issuing judicial authority before the English court. In order to minimize the delay in cases such as this, in practice what happens is where evidence such as was served in this case is served by the defense, it is immediately transmitted by the Crown Prosecution Service to the issuing judicial authority for its comment or response. Now that's not an application of 15.2, which is the power of the executing judicial authority to request further information. It is simply an attempt by the Crown Prosecution Service to try and speed things up, rather than waiting to the end of the extradition hearing, or in this case, the appeal, to see whether the executing judicial authority, here the magistrates' court and then the divisional court, to see whether they make a decision about whether or not to ask for further information under 15.2 or not. We don't wait for that, trying to speed things up. We send the information out straight away and try and get a response rather than waiting to the end of the extradition hearing. And so that's, of course, without prejudice to the power that the executing judicial authority have under 15.2, as here, to ask Hungary to comment on the alleged breach of assurance given by Hungary to the German authorities. Whether that's court or state is not really known. And so that's why some of this evidence was responded to, but the court still had, the divisional court still had the decision to make about whether or not to execute the power that it undoubtedly had to request further information under Article 15.2. Now we say, based on the preamble and all of the jurisprudence, both European and domestic, that it's all to the same effect, namely that as a matter of general approach, the framework decision proceeds on the basis of mutual recognition and a high degree of trust between all member states, and that on the basis of that, that the national legal systems of each member state are in a position to provide equivalent and effective protection of the fundamental rights of those within its jurisdiction. And we say that on the basis, on that basis, in any case where a party seeks to rebut a strong presumption, the court of that member state will not comply with its obligations under the Charter, that clear, cogent, powerful and compelling evidence will be required. Now, all of those words appear in the judgment in Elash Maori, which I've given the reference, that the reference is actually at EF 1475. So all of those words are there, they're quoted in our case, but that is the sort of evidence needed to rebut the presumption. Now, as the appellant has rightly submitted, there are circumstances, particularly with an aging prisoner state across Europe, and it's not only the problems of the Eastern Bloc, or former Eastern Bloc, as my learned friend says, that many countries have criticisms of their aging prison estate. And occasionally things get bad enough for there to be a pilot judgment about it. And as my learned friend has rightly submitted, in this case and in respect of Hungary, there was such a pilot judgment in the case of Varga some years ago. And in such a case, the presumption that I've just outlined about the risk and the state of the prisons is rebutted. And so it becomes a matter for the issuing judicial authority, Hungary and all the others who have been subjected to a pilot judgment, to satisfy the court that they can and will deal with the potential risks involved in their aging prison estate. And some member states have made efforts and attempted to regain that presumption, unsurprisingly. And so immediately following a pilot decision, states such as Lithuania and indeed Hungary started giving assurances to executing judicial authorities such as the UK. In Hungary's case, it turned on two prisons in particular, Szombathely and Tiszilok. Now those prisons are privately run, they're new and are beyond reproach and are generally regarded as acceptable for all purposes and across Europe. And so those two prisons, which are specified in the assurance in this case, are not subject to the same difficulties witnessed at other prisons, older prisons within the estate. But that puts pressure on the issuing judicial authorities because once they've given the assurance that everybody extradited across Europe are going to the same two prisons, those prisons start getting rather crowded. And what's more, occasionally they are geographically inappropriate or difficult for the location of trial or unsuitable for the location of the particular extraditee or requested person. In other words, they're absolutely miles from their families, and that has caused difficulties. But trying to get back the presumption that I've just described and is inherent in the whole framework decision, it's very difficult. and member states have tried and failed. The one my learned friend has referred to, the case of Jane, that was Lithuania, which had made strenuous efforts to improve the conditions within its estate, but didn't quite get over the line in the divisional court here. And so despite trying to stop or cease giving an assurance to the divisional court, they said, look, we've done so much, surely we're entitled to the presumption again. And in fact, it's a very useful and mercifully short judgment that can I take your lordships to about, firstly, the loss and regaining of the presumption, and the part that assurances plays thereafter in the decisions to be made. And it is the judgment of Lord Justice Higginbottom. It's at EF 1616. My learned friend has actually made slight reference to this already, one of the final paragraphs. But in the case, Mr. Justice Dingemans, as he then was, analyses the evidence, including evidence of foreign courts about prison conditions in Lithuania, which is important because we say there is no prohibition on considering the position with other member states, particularly when looking at the overall position. And then following his analysis, at paragraph 52, 1616, is the short judgment of Lord Justice Higginbottom. Can I invite my lords to read paragraph 52, 3, 4, and 5, which are very useful on the interaction of the issues, international consensus, and assurances.
Yes, Mr.
Thank you. So paragraph 52, it's of assistance with my Lord Legate's question. The ultimate question always is and remains, before a requested person can be extradited, the court must be satisfied that there's no risk of him being subjected to inhumane or degrading treatment. And the whole of the approach of the courts is ultimately directed to that issue. It sets a very high bar for countries such as Lithuania and Hungary to regain the presumption that they've lost by virtue of a pilot judgment, that in essence it becomes a burden on them, those member states, to adduce clear and cogent evidence to discharge that burden and regain the presumption. And personally, I know of no country that's managed it after a pilot judgment, that they've managed to persuade the from clear and cogent evidence effectively that there is no risk within their entire estate, which is something even we might struggle with. But very importantly, my lord.
I was just interested in the test of real risk, no risk, and the recital which refers to serious risk. But my understanding of a real risk is one which is neither trivial nor fanciful. So there may not be much of a distinction between no risk and a real risk, if you define a real risk as something which is neither trivial nor fanciful. And is there an authoritative exposition of what the test should be?
Yes. In fact, as soon as I finished on this, we might go straight to it, yes. Because I agree. I mean, the overall procedure that one runs through is extremely important, and the stages, starting with the general and going to the specific. So all I really emphasize before leaving this is the point at 55, paragraph 55. Or although one may have lost the general presumption that you will comply with all the that there is absolutely no risk at all, or that you'll handle the risk, that does not impact directly on the presumption in relation to an assurance, which is described as a solemn assurance, straightforward solemn assurance. I do emphasize, of course, the third and fourth line there. In general failures, its general failures may, depending on the facts, bear on its reliability. So I don't ignore that, and I draw that to your attention, that if the conditions are so bad that can affect the assurance in relation to an assurance. But the reliability will usually be tested in other ways, and that's obviously the Ottman factors and criteria that are referred to in that way. But despite losing the presumption, that generally does not undermine the reliability of the assurance. Now, as for the general approach, my Lord Stevens is absolutely right. It is important to see the procedures, in essence, and the stages that are run through. And it's Aranosi, which commences at EF 595. The oft-quoted paragraphs start at 637. I invite your lordship to 637. And can I invite my lords to read, in essence, the different stages, starting at 88, and it goes over the page to paragraph 96, which deals with the 2 or maybe 3 stage process. Well, my lords, I hope that answers the question asked. One starts with the assessment of the general. If, as a result of that assessment, there are substantial grounds to believe that there are deficiencies which may be systematic or general, one moves to the specific. And again, the individuality is emphasized, but at 94, when determining the specific, the court is bound to determine whether in the particular circumstances of the case there are substantial grounds to believe that following surrender of that person to the issuing member state, he will run a real risk of being subject in that member state to inhumane or degrading treatment within the meaning of Article 4. So it's the particular circumstances of the case, it's the particular person in that state and at that time, and whether substantial grounds to believe a real risk. So I hope that assists. Then one goes to Article 15.2, and the urgency is again commented upon. And we submit that the general presumption.
Sorry for interrupting, but this constantly refers to real risk as opposed to no risk. And I just wanted to get your insight as to which is the correct test. Is it once an assurance has been given, is the test that there is no longer a real risk, or that there is no risk? I wanted to find out whether you think there's any difference between a real risk, because in Article 2 cases, under Officer L, a real risk is defined as something which is neither fanciful nor trivial.
Well, it's real risk. It's constantly referred to as real, which is neither fanciful nor trivial, but it's also substantial grounds for believing. So that's I know that is
the substantial grounds for believing would be the appalling conditions in the prisons. you
yes.
have to rely upon the assurance to dispel those substantial grounds for believing.
Well, that's absolutely right, my lord. And some of the judgments talk about dispelling the risk, and they talk about, is the assurance sufficiently of sufficient quality in the Ottman sense that the risk that undoubtedly has been identified, the systematic risk, it has been dispelled, and that is the word that's commonly used.
Mr. Hines, is this just one manifestation of the serving duty?
Yes, yes, it absolutely is. Yeah.
Which is usually expressed in terms of a real risk.
Yes. Well, a lot of this authority does stem from Suring, from that seminal case.
Thank you.
And what we say is when one is approaching, when the executing judicial authority, the court here, approaches the issue of the assurances provided by another member state or an issuing judicial authority, that, as your lordships have already seen in Dora Bantu, the general approach is that the executing judicial authority must rely on an assurance given, and only in exceptional circumstances and on the basis of precise information, as we've seen in that paragraph of Dorobantu, can an executing judicial authority find, and as it says, notwithstanding an assurance, there is a real risk of the person concerned being subject to inhumane and degrading treatment. So the real risk appears again there. It's the paragraphs you've already been taken to, 68 and 69 of Dorobantu, and that, as your lordships have already seen, is at EF 674. So curiously, we too rely on the same paragraphs as the appellant, but for different reasons, namely the general approach to assurances. On behalf of the respondents, we accept, and we always have, that there are no hard and fast rules in relation to the source or type of evidence needed to displace
Right, we've lost Mr. Hines for the moment,
Mm.
and we'll suspend the hearing for the moment. We'll see if the technicians can get Mr. Hines back. He's now.
I'm
Well,
sorry,
we'll
I took a break.
We'll resume the hearing. Mr. Hines, you were in the middle of making a submission. You said that you accepted there was no hard and fast rules to the type or source of evidence.
Or indeed the type of evidence needed to displace the presumption that I've outlined. And so we do not submit that evidence relating to breaches of an assurance given to a third member state, such as Germany in this case, is of itself undoubtedly inadmissible to the court's assessment, either to the risk of a breach of Article 4, or indeed the assessment or quality of reliance on the assurance given. That there are no bright lines, and we don't suggest that there are. But what we do say is actually back to the point on fresh evidence, that there is a distinction to be drawn between admissibility of fresh evidence in this case and the weight to be attached to the evidence presented on behalf of the appellant. And we say that the appellant in this case is conflating those two concepts of admissibility and weight that ultimately, and I can deal with this straight away, the court here at its core was determining an application for fresh evidence. And to make that good, can I ask my lords to go to the judgment of the court at paragraph 2, which is EF 69. Where it's clear from the introduction that the court was determining leave to admit fresh evidence, the expert report, and also that the court had agreed to consider the material that was being presented in the expert report de bene esse, and rule on its admissibility under section 27, having considered the evidence itself. The same point can be made in paragraph 31, which is at EF 80. In fact, the relevant part is at the top of 81. As we've already indicated, we agree to consider this evidence de bene esse. And as my lords have already observed, the wording of paragraph 78 makes the position absolutely clear. In light of our conclusions, it's clear that even if admitted, we do not consider that the fresh evidence advanced would afford a general ground of allowing the appeal, still less it would be decisive, a reference to the wording of section 27. And in fact, when we look to the chronology in the case, which is at EF 40, this is the agreed statements and facts, where a chronology is set out at EF 40. We see it was the 23rd of November 2018 where the application to adduce the evidence was formally made to the court. And that was a formal application to adduce fresh evidence before the court. And so it's simply not right to say that the court were not considering Fenovese and the application of section 27 of the Extradition Act, which makes clear and has been an unchallenged interpretation, is that it would have to be decisive evidence before it was admitted. And they dealt with it as a matter of admission of evidence. Now, my lord.
The proposition in, do you seek to defend the proposition in paragraph 44 of the judgment as a proposition of law that the general application?
Sorry, I'm afraid that the line broke up there. I didn't hear that. I didn't understand.
Sorry. I was asking whether Mr. Hines seeks to defend the statement in paragraph 44 of the divisional court judgment as a proposition of law of general application.
Yes, I do. What we say, in fact, is that it's really no different from the test described in many of the cases. The wording used may be slightly different, but in essence, the idea that what one needs is credible evidence, which is relevant, directly relevant, and of real importance, in our submission, are uncontroversial. That if one is going to reject a submission, an assurance given by a fellow member state, what will be needed is some manifestly credible evidence which is relevant and of real importance. We say actually that that's no different from the test in respect of displacing all of the presumptions, whether it's about the risk or whether it's about the quality of the assurance. But what is the difference we submit between that and clear, cogent, powerful and compelling evidence, those words used by Elash Marwi? What in substance is the difference between the Elash Marwi test and the test in 44? The key to displacing evidence must, we say, be the believability of the evidence, its relevance and importance. It isn't a new test, and the divisional court, we say, wasn't seeking to introduce a new test of admissibility. It was identifying the key qualities of evidence which will be required to displace presumptions about the good faith of an assurance given.
But that's not normally a test of admissibility, is it?
No, it's not.
And
yeah.
Here it's made into one.
Well, I agree that the word. One thing that we have pondered on long and hard for the respondents is whether the court was propounding a test which applied to assurances generally, in other words, the quality of an assurance given, for instance, to the United Kingdom, or whether this was for application only, or it was suggested it was for application only, where the assurance was given by a third member state. And to that extent, we find ourselves agreeing with the appellant that we can see no distinction between the approach that should be adopted to assurances given to the United Kingdom and assurances previously given to, say, Germany, as in this case, that although they do use the words, having regard to these conditions, we conclude that a court would be satisfied itself, would have to satisfy itself that the evidence relating to assurances given in extradition elsewhere, so they do make mention of elsewhere, in other words, suggesting that perhaps this is the test that applies only in respect of assurances given to third member states. But for our part, we can't actually consider that this is any different from the test one would apply to assurances given to the United Kingdom, that in essence they too, if they are to be displaced, must be displaced on the basis of precise information, as it says in Dora Bantu, and that must be manifestly credible evidence, directly relevant to the issue and of real importance. Otherwise, you accept the assurance at face value and in good faith. And so, for our part, I'm sorry, my lord.
In relation to Dora Bantu, what do you say about the appellant's point that the comments there relate to assurances given by the judicial authorities?
Oh, well, we say that the divisional court have got that absolutely right. That they deal with it. In fact, at paragraph 75, as my learned friend has indicated, that's at EF 88. And it's absolutely right for the reasons that they outline.
Well, I think the point being made was that in paragraph 75, they've rather misunderstood the argument, which is not that you can only accept assurances from judicial authorities, but that the restrictive terms of exceptional circumstances and so on related to assurances given by judicial authorities. What do you say about that?
ML, which is an important authority and reiterates exactly the position, was indeed a Hungarian case with an assurance given in exactly the same terms or from the same body as gave the assurance in this case. But the position is that the judiciary don't control the prisons. And so the point is made, and it's an accurate one, that in fact it's almost bound to involve the Department of Justice in a state who has better control. I'm not suggesting that the court can't evaluate any assurance given by anybody, but in my submission, there really is nothing in the distinction that my learned friend makes in this case. The divisional court rightly rejected the distinction. My lord.
Does a different test apply depending upon whether the assurance is given by a judicial authority or whether it's given by some other emanation of the state? And if so, what is the difference?
We'd say no. We'd say it's the same test. It's the Ottman test, where there is a serious challenge to an assurance given that must be considered as against the Ottman criteria, and they are many, and they do involve looking at who's given the assurance and ensuring that it is reliable.
And the Ottman category 11, what's the outworking of that?
Can I just get it out?
sorry to fire these questions at you.
No, it's all right, Lord. It's just a question of getting to Oppmann.
It's 10:33 in the electronic bundle.
I'm obliged. Yes, I do have it now. Whether the reliability of the assurance has been examined by the domestic courts of the sending contracting state. Yes, the answer is that that's undoubtedly a factor. I'm not saying that there can never be a significance in where or who gives the assurance, but in all cases, whoever gives the assurance, the Oppmann criteria are applied, all 11 points of them. Yes, I mean, it's also point 3. Who has given the assurances and whether that person can bind the receiving state. So it's the practical effect of the assurance. My lord.
Yes, I'm wondering if you can just help me as to where your submissions ultimately lead. I mean, clearly we've been given a point of law of general importance to answer. And I'm now just not entirely clear how you would ask us to answer that question. The question, of course, is on page 67 of the electronic bundle.
Where a court is obliged to assess an assurance given to the United Kingdom relevant to extradition, is it correct that the court should exercise very considerable caution before admitting evidence which does not relate to the alleged previous breaches of an assurance to the United Kingdom, but rather to an alleged breach of an assurance to another member state? The answer is yes. The court should exercise considerable caution before finding the facts. One of the distinctions again here is the evidence which was presented to the divisional court was from a man who allegedly had spoken to a representative of the firm of lawyers in Hungary and had said, oh, by the way, I was extradited from Germany and the assurance given to Germany was breached, and that was it. And so they had little more than that. What we conceded before the court below was, of course, there is no rule prohibiting the court from considering evidence of breaches given to other member states. And indeed, that's exactly what happened in James. There was consideration of judgments and findings of various foreign courts in respect of Lithuania. But ultimately, what we said is it's very difficult for the divisional court, faced with a report from a firm of lawyers in Hungary, who say that they've received this account from somebody who was extradited from Germany. It's very difficult for the court under those circumstances to make findings of fact about it.
Yes, no, I accept that, Mr. Hines, but the wording that you've answered yes to would, on your submission, be rather peculiar, because you've just told us, I think, that you would apply the same answer whether the assurance was given to the United Kingdom as you would to an assurance given to another member state.
Yes, my lord, I'm saying the test is the same, whether it's precise and whether it's credible and important. But it's
right.
Rather...
The first question we were being asked in relation to this point of law of general public importance seems to be drawing a distinction between the two types of assurance. So we can't just answer that. I mean, it would be odd to answer that question yes, would it?
Well, maybe it doesn't quite give of a simple yes or no answer. Is perhaps the difficulty that I'm struggling with. What I'm saying, in essence, is that the divisional court did not come up with a new bright line in relation to the admissibility of any evidence.
Well, that was going to be my second question, because on the face of it, this looks like a special rule of admissibility. But you're saying that's an incorrect reading. You're saying that this is simply a reminder that one's got to be careful when assessing the weight of the evidence. Is that right?
Yes, in part, my lord. It also involves the difficulties in making findings about breaches of foreign assurances. And can I take you to the reasoning of the divisional court in that regard? Because we say, in essence, that it's the same concession we made below, and they rightly focused, we say, on the bilateral relationship with the United Kingdom. In this regard, it's at EF 82. No, it's about EF 81. Can I start at EF 81? My submission was that the UK court was not the appropriate forum to make factual or evidential findings in relation to such breaches. And that's for the practical reasons that we see on EF 82. What the court said is we do not rule out this type of evidence. They say I was right to make the limited concession. If a serious issue had been raised as to whether another state will in fact treat a person extradited from the UK...
Which paragraph are you reading, Mr. Hines?
37.
37, thank you.
At the bottom of 81.
Yes.
This court is not precluded by any rule of law from having regard to any material evidence bearing on that issue. So they very explicitly emphasized that they were not introducing an exclusory rule. What they were doing was the very opposite. They're saying, look, if there's a serious issue, we're going to look at this, and we're going to look at it whether it's a breach of assurance to the United Kingdom or another member state.
Mr. Hines, the difficulty with that is that if you go forward to paragraph 44, the court is laying down the conditions before it can be invited to admit and consider evidence.
Well, that's back to the fresh evidence. It's relevance and admissibility. Admissibility is judged by reference to Fenovese and section 27. The relevance and weight to be attached.
But is it considering admissibility of fresh evidence or admissibility generally?
Well, in my submission, they didn't purport to exclude, so it can't be admissibility generally. And that's really the point of 37, that they absolutely emphasized, as I did, that of course you can look at breaches of foreign assurances, but there are tensions, and it is difficult. And the difficulties are outlined in the important paragraphs in between 37 and 44, my lord.
In 38, before they embark on that, they say exercise caution will ask to admit and evaluate evidence. And then they're going on to say these factors before you start evaluating. 40, practical difficulties were asked to embark on an exercise of evaluating them. It doesn't make much sense, does it? Because you have to evaluate the evidence in order to decide whether you can evaluate this.
Well, that's absolutely right, my lord. But what we say about it is this: that 39 is the focus must be on whether you can rely on the assurance given to the United Kingdom. And that we say rightly the central relationship that is in contemplation, because that goes fundamentally to the reliability of the assurance. And we will see this. I'd like to take you, please, through some of the paragraphs in Ottman and how they came to paragraphs 187 to 189. But the central focus is, as was said in Fusesi, what is crucial is that there's no evidence of a breach of assurance to the United Kingdom, and indeed there wasn't. Of the practical difficulties, they are real. The court didn't have the assurance, so it couldn't examine its terms. Their right to observe that the full context of the breach may well be important. The stance of the third member state, in this case Germany, in relation to an alleged breach is very important. Whether there were remedial actions taken in respect of it, and whether there might be legal...
These are all case-specific things, aren't they? You
Yes.
might have a case where you had a judgment of German court which made factual findings on all those matters.
Yes, and
Or you might have a case where there's no real evidence about whether the English assurance given to the English court in the past was broken or not, or it's very unsatisfactory. It doesn't depend on necessarily on the country to whom it was given.
it's all fact specific, but our general proposition is that the central focus is, of course, the bilateral relationship between the two countries in assessing the quality and reliability of the assurance given. If there was a German case in relation to a breach of assurance, I, for one, would struggle to resist the admission of that evidence, certainly at first instance. I might be able to argue a fresh evidence point, but it would be admissible. It's the underlying facts which are so difficult to find. And in fact, the court must assess, of course, the quality of the evidence. There's a very good example, in fact, referred to in the judgment about why it's so important to understand the full context and the stance, if you like, of the third state. It's the two Indian cases which were referred to in the judgment of Patel and Shankaran. And the background, they're a good example of the difficulties that can arise. The requested person in the case was in the United Kingdom. His extradition was requested from India, and on his behalf, an assurance was given to the English court about something, I think, specialty. And on his behalf, it was submitted that the assurance given by India couldn't be relied upon because India had given a similar assurance to Portugal, and the Portuguese Supreme Court had come to the conclusion that the Indian court had broken that assurance, and in breach of that assurance of specialty, the rule that you're only tried for the offences for which you're extradited, had tried the relevant appellant, Mr. Ansari. And the court had to consider that evidence. And it's at EF 1619. Oh no, it's not a DF 1619. 1696, sorry, my lords. And it's paragraph 83. It was Mr. Fitzgerald, Queen's Counsel, that put the material regarding Mr. Ansari's extradition before the court and said as a result there was a real risk that the government of India would violate specialty in the appellant's case. But once they'd taken into consideration, well, may I invite you to just read that paragraph. My lord.
I think the Ansari evidence has been relied on or attempted to be in many cases, Mr. Hines, and you've probably come across it more than once, but that's relations between different countries in India. Can you suggest any reason why within Europe, when we're talking about Germany and the UK, that there should be any difference applied, just because the assurance was given to Germany rather than the UK?
The answer is, firstly, we can't make any request of information from Germany under 15.2. Secondly, the divisional court in this case assessed the evidence and in fact came to the conclusion that if they were in essence troubled by it, they would have made the application under 15.2 for information about it from Hungary itself, even though that would without doubt involve what they described as satellite litigation and further delay. But they would have made the request for information if they had seriously been troubled by what was placed before them. But in essence, it comes down to the bilateral relationship being the fundamental relationship to be considered.
Well, that's my question, really. Is there any reason to suppose that the UK might have a specially favourable relationship with Hungary that other countries like Germany don't? It seems an odd starting point.
Ottman identifies it, and it identifies it with good reason. Can I actually take you through Ottman just a little bit more deeply to show how they got to the judgments that we've seen? Ottman was a SIAC case, the security people. And can I take you in this regard to 987? Where the court consider the ruling of a Swedish case and Egypt, and I agree this is not European, but it's the rationale for the original decision which I draw attention to. In the case of Agizi, it's the indented quote. There was a clear warning of the dangers of simple reliance on the form of words of diplomatic monitoring, already warning signs with the Swedish authorities. But I emphasize this, but we note what to us is the crucial difference, the strength, duration and depth of the bilateral relationship between the two countries by comparison with any that has been pointed to between Sweden and Egypt. And so they are there comparing at least the different relationship. At the bottom of the same page at paragraph 30 in the 5 lines in, the line starting by its terms and spirit, each country has a real interest in preventing breaches of the MOU. The diplomatic relationship between the United Kingdom and Jordan was friendly and long-standing and of real value to Jordan. Real incentive to avoid being seen as having broken its word. That, of course, is the first instance decision. I draw attention briefly to 994, EF 994, at the end of paragraph 49, which may be of significance. It's the last, effectively, 4 lines. It's the second Roman 2 point. The relevance of assurance to safety on return was a matter of fact, not law. And thus, I think then the House of Lords had no jurisdiction to entertain an appeal on that ground. The Court of Appeal also rejected the appellant's appeal based on Article 5, that the SIAC were entitled to find as they are. So that's fact, not law, and we commend that. On to a description of the judgment of Lord Phillips at 996, paragraph 57. An assurance is part of the matrix that has to be considered, whether there are substantial grounds for believing that the applicant would face treatment contrary to Article 3, and there was an abundance of international law material which supported the proposition that insurance should be treated with scepticism if they're given by a country where inhumane treatment by state agents is endemic, which was then described as a catch-22 on the basis that if you need to ask for an assurance, you obviously can't rely on it. But he rejects that approach at the top of 997. Can I then take you to the judgment of the European Court of Human Rights? It's at 1026. The government submitted that the materials on, well, can I invite you to read paragraph 161? These are the submissions of the parties, I acknowledge, but it's showing effectively where the court, how the court arrived at its judgment. Then to 1027, paragraph 164, perhaps just 164.
So what submission do you make, Mr. Hines, on the basis of this?
What I make, the submission I make is that although, of course, the European Union is a collection of member states, that the courts rightly focus on the bilateral relationship between the executing judicial authority here, the UK, and the issuing member state. That in essence, that is the key relationship which the court can understand and on which the court has the greatest insight. These breach of assurance cases are and can be quite difficult. In this case, some of the evidence was rejected very often there are proceedings in, for instance, Hungary. We know that they have an ombudsman system where complaints about Article 3 breaches are considered and facts are found. And so our submission to the court below was because of the difficulties that arise where the court is invited to make factual findings about whether there has been a breach of assurances given to a third member state. In the absence of a judgment or something such as that, they ought to tread carefully because one doesn't know the context, one doesn't know the relationship, one doesn't know other whether there's been any legal proceedings about it, etc.
Isn't all of this a matter of weight to be given to such evidence as there is?
Absolutely. That effectively is our submission.
And that'll be a question of fact in every case.
And that's a question of, it's an absolutely fact-sensitive fact. There's no bright lines. If the evidence of breach of a foreign assurance is powerful or compelling, then the court goes there, in essence. But effectively, it needs to be good. My lord.
Isn't it rather important, though, that Germany, unlike India, Jordan, and Algeria, is subject to the framework decision?
Well, it is, but the question is the evidence that was presented about breach of a German assurance wasn't that good.
I totally take that point, but I'm just pressing you on the question, which perhaps you don't really seek to defend, that the identity of the country is itself a significant factor if it's in a context of another European party subject to the framework decision.
Well, I say that Ottman rightly identifies the bilateral relationship, and so in fact does do other authorities, and it's the easiest one to assess and apply. The question is, there is a solemn assurance given to the United Kingdom, and the court must assess whether it can rely on the solemn assurance given to the United Kingdom. I think in one of the authorities, yes, in fact, it is in Ottman, having run through 187 to 189, which I know you've read. Can I take you to page 1034, which is paragraph 193. And in fact, it's the last 7 lines of the page. There's a line starting, general submissions are supported by, if I could take your lordships to just those last 5 lines. And that, we say, is the proper approach.
That's Jordan.
Yeah, that's Jordan. But even if it's Europe, we say exactly the same applies. That as a general rule, there is no absolute rule that the state can't comply, which can't comply with a breach of an obligation to Germany, won't comply with the bilateral assurance given to the United Kingdom. But that could be a factor in determining whether the bilateral assurance is sufficient. What the court are doing is effectively determining whether the bilateral assurance is reliable, and a factor, of course, can be a breach of assurance to a third member state. And we've never argued otherwise. We just say, tread carefully if you're being asked to find facts, because context is all, and there are practical difficulties about that. And do examine the quality of the evidence. That really was our submission, my lord.
Is there any material difference between the bilateral relationships as between the states members of the European Union?
No.
Then why is it in the least bit relevant?
Because it's difficult to make the factual underlying findings.
Okay. What is the difficulty about actually asking the requesting state as to for the terms of the assurances that they gave to Germany?
They could have, and they concede they could have. And what they said is, if we'd really thought this was serious and would have been decisive, we would have. Right. And that's in fact how they put it. Well, actually, that isn't. That's how I put it. But actually, we better just go to how their lordships put it.
Well, certainly that would be a test, wouldn't it? If there was a concern about it, you would make the inquiry. But I was just wondering, how concerned do you have to be before you make the inquiry?
Can I just?
I suppose it's there still is a real risk. I suppose you come back to that test. Do you?
Yes, if it was a serious issue, I think is how they. It's paragraph 70 of the judgment. Can I just see what page that's at for your lordships? Yes, it's EF 88.
Paragraph?
The reasoning starts at 69. It's the first few short paragraphs. My lord.
Shouldn't the test be as to whether you ask a question, whether the answer might make any difference to the outcome of the decision, the outcome of the case?
Absolutely. And the point they really make at 72 is they had considered what were allegedly breaches of the assurances given to the United Kingdom. And so it's not that they were without evidence. They had considered various alleged breaches of the United Kingdom, which they then said were either short or rectified quickly, or I think one was an allegation which was made. Hungary responded to it, and the allegation was immediately withdrawn. I mean, it was a very good example of potential unreliability in these cases. But having considered the 4 breaches, of which 3 I think were pursued, of the alleged breaches of the United Kingdom assurances in the past, they concluded that they didn't cut it such that you couldn't rely on the Hungarian assurance. And looking at the evidence, even if proved, they came to the conclusion that the breach of the German assurances wouldn't have made any difference, wouldn't have been decisive. And it's clear that had they thought otherwise, they would have made the request. They weren't put off by the fact that data protection in Hungary, certainly in the first instance, prohibited disclosure. They said, in essence, never mind that, they can work it out and give us the information if they'd actually wanted it. So they didn't. Firstly, the refusal wasn't exactly that, and secondly, it certainly wasn't an impediment to the exercise of 15.2. But one always comes back to the urgency and time limits, and what use should be made of 15.2. What should you use 15.2 for? We've seen in Aranosi that in essence they say 15.2 is to look to the precise conditions that will be provided, if that's the right word, to the requested person upon his return. So look to where in fact he will be housed. And in this case, as I say, Som Bethely and Tissilock are not subject to the same criticisms as others. Now,
if that's a convenient moment, we'll take a break now and we'll resume at 2 o'clock.
Thank you, my lord.